Hello, everyone. Welcome to Court with Krissy. Okay, picture this. It is May 2020. COVID lockdown is in effect. You're lucky enough to snag a divorce hearing, and then you're moving to Florida to start your life over. Fast forward to present day, and you're going back to divorce court. Wonder why? Watch and find out. I hope you like it. Court with Krissy is now in session.
Let's go ahead and go back on the record. I will take up the 1015 matter, which is Schaub versus Schaub, file 20-35195-DO. It's the time, date, and place set for an order to show cause. This court issued an order on March 20th of 2024 to the plaintiff to appear today at this hearing. With us, we have the defendant, Ms. Schaub. And I don't see that we have the defendant with us. Ms. Schaub, you can see and hear me. Is that right?
Yes, I can, sir.
All right. And are you aware as to the location or status of Mr. Schaub?
All I know is that he's in Florida, and I know that I know that he got the message, even though if he didn't get the letter right away, because he had his address here. He hasn't been here in 4 years. He walked out a month after, and he made all these promises and didn't keep up to any of them. And I've been like drowning here.
Let me stop you for just a moment. Okay, we'll do one thing at a time. How do you know that he received this message?
Because I texted it to him, to his number, and then his sister always wants to be in the middle, so I texted it to her, and he come back with some not so nice comments toward me. So
okay, bottom line is he communicated with you at that same time, so you have reason to believe he received this information. Is that correct?
Oh yeah, I know he did. Yeah.
Okay. All right. I set this matter because you supplied a letter to the court indicating that you had not been able to take action with regard to the order of divorce in this case, specifically with regard to the sale of the property. That is the property that's owned in the marriage. And you indicated that was because the plaintiff has not been in contact with you. His name remains on the deed. Is that what I'm hearing from you?
Yes, sir. Yes, sir.
All right, let's go ahead and put some information on the record. And when we do that, that'll give me the ability I need to make a decision as to where we go from here. So please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, Ms. Schaub, you were the defendant in this divorce action, correct?
Yes.
And in the judgment that I entered in May of 2020, it was indicated that you and your husband, the plaintiff in this action, would sell the property that was owned by both of you and divide the proceeds of that sale between you. Is that correct?
Yes, sir.
Have you been able to do so?
No, sir.
And the reason for that is, you've explained to me, because the defendant has not been cooperative with regard to providing.
Mr. Schaub is now here.
Oh, he is. Good.
I'm asking him to unmute and start his video. I'm just waiting for him.
Okay.
Okay, you're Mr. Schaub, is that correct?
Yes, I am.
And you are the plaintiff in this action, correct?
Yes, sir.
All right. Well, I'm glad you appeared. We also have the defendant, Ms. Schaub, with us today. The reason I ordered you to appear today is because I received a communication from the defendant indicating that the property that I had ordered to be sold by the parties as part of the resolution of this marriage has not been sold. She's indicated to me that The reason for that is that she has not been able to secure your signature either on the deed or to pursue the sale of that property. Mr. Schaub, are you able to go ahead and participate in the sale of the subject property?
Yes, sir. We actually had signed papers just past week to go ahead with the realtor to open on the market.
All right, just a moment. Ms. Schaub, is that accurate?
Yes. It's been on the market, and there's been for sale signs everywhere.
Well, wait a minute. So the property has been marketed for sale, Ms. Schaub. I don't think that's what you told me. Is that right?
No, it's on the market. It's with,
Okay. Then Ms.
but
Schaub,
he just recently, when I relisted it with, that's when he jumped on the boat. That's when, and then I got the letter in the mail that he was in contempt. The point is he has not paid anything to fix up, to help, to do anything until it inconveniences his little life. I'm not the one that ran away from this marriage. I'm not the one that wanted it to end, but he sure was. And
all right, so let's stop for just a moment. You've indicated that you haven't received any payment related to the property. The order indicates that both parties are responsible for the mortgage, insurance, taxes, liens, and any other costs or debts associated with the property. What do you argue or allege that he owes you then for those payments since the entry of the divorce order?
well, he hasn't paid anything. We're like, I'm trying to keep it out of foreclosure. If it goes in foreclosure, we both lose.
So what?
He's not paid a single tax. He
Okay,
didn't pay for the plumbing.
Stop. Okay.
Okay.
I need you to listen because we're recording this, so we can't talk over each other. And I know that this is emotional, but my job is to get past the emotion and make a good decision based on all the facts and evidence. Okay. So you
Right.
answer my questions, not go into a statement about
Okay.
things. So be specific. What are the amounts that you are owed? It told me that you've made all the payments on the property since the divorce. And how much is that?
So far it's over $700 that I've paid toward the taxes to try to keep them up. I'm on disability, kind of hard to do, but I'm doing it.
Okay, hold on. So you don't know the exact number today. You're in court, you don't know the number, is that right? That's a yes or no.
Hold on a second.
How about the mortgage payments? Let's start there.
We don't have a mortgage. It's just taxes.
Okay. Insurance?
No insurance.
All right.
It's a
So
trailer. Just
you
the,
you
what? You
Yeah.
cut out.
Boy, you just need to wait for me, okay? We're talking over each other, and that makes for a very, very difficult record. So just wait and respond to my questions. So in terms of the taxes, do you know since 2020, when this matter was resolved by order of the court, how much you've paid in taxes?
$740
Total?
total.
So what you're seeking is payment by the plaintiff in the amount of one half of that. That would be $370, correct?
Yes, sir.
All right. And are there any other issues with regard to expenses associated with the property that I need to be made aware of now that you're seeking recovery for?
The plumbing was done.
And how much
Sorry.
is that?
Total plumbing was $530.72.
Anything else?
The septic was $618.
Anything else?
Propane tank was put in at $100 deposit.
So the trailer uses propane for heat, is that what you're saying?
Yes. I've had the furnace had to be fixed twice. That was $150
Each time or total?
each time.
Any others?
Nope.
Okay.
That's it.
All right. So Mr. Schaub, do you dispute any of those charges?
Yes, sir, I do. When I moved away into 2020, in October of 2020, I moved to Florida. At that point there, I told her that we're going to have to sell. It's best that she just leave the place. We'll sell it. Until that point, there was no communication as far as how much it was. She wanted to dictate how much she wanted to sell it for, which was fine. We can dispute each other over price. In 2021, I paid the back taxes of, I believe it was between $1,600 and $1,900 for 20, I believe it was for the 2020 taxes, which was overdue.
How much was that you paid? If
You
you're
know,
guessing, if you're guessing,
I'm
that's not
guessing
helpful.
between $1,600 and $1,900.
All right, so you don't know exactly what you paid, is that right?
No, sir, I have not been able to look up the records. I know it's in there someplace, Grand Traverse County records. Most of the lists, most of the taxes that were paid on that property were paid by me throughout our years of marriage.
All right.
I owned the place before we were married.
So let's talk about the expenses associated with the upkeep. I understand you wanted to sell the property immediately. It wasn't sold. Not much I can do about that. That's history. And
Yes,
the
sir.
property was retained by both of you, technically, according to the order, for these 4 years. So the expenses would normally be distributed evenly amongst you. Are there any issues that you have with regard to the amounts that were paid here?
Yes, sir. She chose to live there. As far as I understand, with the divorce decree, says that we're responsible, split evenly between the mortgage, liens, taxes, insurances. As far as living expenses, she chose to stay there and live there. So it's up to her to upkeep, in my opinion. Because her toilet breaks down, sir, I don't see where that's my responsibility.
I understand. I completely get your position, but your order says that any costs associated with the property are to be split evenly between the parties. I recognize you're living in Florida. You don't know what's going on with the property, but that was the order that you signed back in 2020. So look, guys, here's the reality here. The taxes, the total taxes that have been paid since 2020 need to be calculated. Once they're calculated, they're divided evenly between the parties. And if the taxes, let's say hypothetically, are a total of $4,000, then the division is $2,000 each. If one party has paid more than $2,000, that party is entitled to receive payment from the other party. It sounds like both parties have contributed to the taxes since 2020. So somebody's going to have to do that and get that information. It's not me. You need to come to court and be prepared to give me that information. And once I have it, I'll certainly order the other party to make that payment. That's number one. Number two, with regard to the expenses associated with the property, I understand the plaintiff's concerns, given that he hasn't been living in the property. But the reality is the order that was entered back in 2020 is your order. It's what I've got to follow. I can't create it out of whole cloth. I have to enforce your agreement. And that agreement says that the expenses associated, the costs associated with the property are to be split evenly. That means that the plumbing, septic, propane, and furnace expenses are to be divided evenly between the parties. At the end of that, we will determine exactly who owes what to whom. But I need to know, and I don't have enough information before me today, exactly what it is that is owed by the parties. So here's what we're going to do. Ms. Schaub, I'm going to go ahead and reset this matter for hearing at my next hearing date, which will be sometime in May. We will at that time expect that you and Mr. Schaub will have all of your ducks in a row with regard to the payments that you've made. And those payments are going to relate to the items that you've told me about today. Taxes, number one, since the date of judgment, which is May, just a minute, let me get the date correct here for you, which is May 4th of 2020, and the expenses that you've described to me, the plumbing, septic, propane, furnace. We're not going to deal with anything else, just those. So I need the tax amounts, who's paid them, and I need proof of the plumbing, septic, propane, and furnace. And we'll come together, we'll figure out exactly who owes what to whom, and that will wind up being an
Grant, you just kicked out
Crossing.
Judge Elsenheimer.
All right, I'm not sure why I was kicked out, my apologies, but I'm back. That will wind up being an order of the court, and the parties will be responsible for paying or amounts. Are there any questions, starting with you, Mr. Schaub?
Yes, I have quite a few questions. The situation that's in hand, that we are trying to sell the place, it was listed in the market for $79,900 with the price and the paperwork were signed. Miss Schaub there, Miss Brown, I don't like her having my name. Miss Brown has told the realtor to take it off the market until after this hearing, and then proceed to tell her that she wants $100,000 for the property, which is astronomical and it's unreasonable. I don't believe we're going to go anywhere further than this if we cannot come to an agreement how much we're going to sell this place. I've already, in that situation, have told that has come to me and says she wants me to pay the closing costs. She wants a half of this. She wants half of that. I went ahead and, because I want this behind me, I agreed on paper with my signature and hers that we will sell the property, split the cost, and I will cover any of her expenses that was incurred with what I have to pay. We've done this. We've already here. We're at that point of doing this now. Why I was called into here now, I have no understanding. I've paid the taxes there for over 20 years. If anybody hasn't paid the taxes, and I don't.
All of this will come out in the wash when we have this hearing in about a month, because you're going to have all that information, as will Ms. Schaub. You'll present it to me, and I'll use court time, valuable court time, in order to resolve something that you guys should have resolved 4 years ago.
Yes, sir.
In terms of the sale of the property is going to be sold. So if one party or another is artificially inflating the price of the property in order to avoid sale, well, that's not going to stand. We're going to get the property sold so that the parties can move on with their lives. And that means that may well be charged with coming up with a price that will be attractive to a buyer, an arm's length buyer in the county in which it's located. Okay. But that's something we'll talk about more in the next, at the next meeting that we have, as I said, in 1 month. Any other questions, Mr. Schaub?
No, sir.
Ms. Schaub, do you have any questions?
No.
Okay, we'll set this matter for a continued hearing in 1 month. I want the parties to be prepared to give me the expenses only on those matters I've discussed. We're not going beyond that. And we'll come up with a number. If you want to communicate with each other and figure it out ahead of time, feel free. But at a minimum, we'll plan on doing that when we meet again in 1 month. I'm requiring that both parties attend. So if you fail to attend, you'll get notice from us as to when that is. If you fail to attend, you may be held in contempt of court. Does everybody understand?
Yes, sir.
All right, very good. We'll see you in a month. Thanks, everybody.
Thank you.
Thank you.